Welcome to the League of Women Voters of Washington interviews of candidates for Supreme Court Justice in the August primary. The League is a nonpartisan organization. We never support a party or a candidate. My name is Eileen McCracken, and my guest today is Dave Larson, who is running for position 5 on the Washington State Supreme Court. We are asking all the candidates the same 4 questions. Each candidate will have up to 90 seconds to answer the question, and the answers are timed. This video of candidate Larson's responses will remain on our website until after the primary elections on Tuesday, August 4th, 2026. Candidate Larson, thank you very much for agreeing to this interview and seeking to serve in public office. Our first question is, what are the benefits of being or not being a judge before running for the state Supreme Court?
Well, first of all, thank the League of Women Voters for all they do and for doing this. It's very much appreciated. But it's actually essential to be a trial judge, because when you're on the Supreme Court, you're sitting in judgment on the errors of trial judges. The NFL doesn't use former players to do instant replay. So it's essential. And I was a trial lawyer for 23 years handling civil litigation. And so being that combination of actually trying cases and then also hearing cases as a judge is crucial, because it's the little nuances that make the difference. Also, I ran a court for 16 years, which is essential when the court is passing rules on how the courts run and everything else, to know the impacts. Because if you don't have that experience as a trial judge or a trial lawyer, first of all, you're not going to understand the nuances that go into making decisions as when you're in the heat of battle. And also, when it comes to administering courts, you're not going to know what the impacts are when you create court rules and that type of thing. So the example is trying a case where there was ineffective assistance of counsel in a case. And I recognized that what I needed to do as a trial judge was to do some things that the lawyers didn't understand what I was doing. But I made that case so it was tried once, and the appeal, there was no appeal from it. As a judge, as a trial judge, I was reversed once in 18 years, so I know how to hear cases. And so, again, when you're sitting in judgment on what trial judges and trial lawyers do, that experience is absolutely essential.
Thank you. Second question, how would you approach a case in an area of law with which you have no knowledge or experience?
And that would be very common for everybody, because it's not possible to have experience in every area of the law. And what you'd have to do is make it your point to learn everything you can about that area of law. Now, in the Supreme Court, you can't go beyond the record. You can't go out and do all kinds of independent research and everything else. But in order to make that decision that you're being asked to make, you have to understand the law and how it works. And if you don't, you seek out people that do, and try to get as much information as you can. Again, with staying within the record, staying within the rules of ethics, because you're not allowed to go do an independent investigation. But to learn as much as possible, because again, your decisions have huge impacts, and if you don't familiarize yourself with that area of the law, you're going to make mistakes. So there's things like looking at case law, looking at statutes, looking at the briefing of the parties, because they're going to know the law a lot better than you are. And then also being skeptical of what they're putting, because they're there as advocates, and making sure that you understand some of the nuances that maybe they're not telling you. So I think that's absolutely essential. And every justice that's sitting on the court, every candidate in this race will have those times when they're going to be confronted with something that they haven't been confronted with before. And I think it's not only it's a duty, I think, to make sure you're fully versed before you make decisions.
Thank you. Third question, when is it appropriate for the judiciary to overturn a statute or popular referendum?
Well, there's actually case law in it, and it has to be clearly erroneous and then harmful. Those are the two elements. And, public trust and confidence in the judiciary is very important. And that's why you have to exercise restraint when doing that. You can't just cavalierly go in and overrule cases or reverse previous decisions, because that precedent is something, like I always say, the courts are the lighthouse in the storm, not a ship lost at sea. And then that lighthouse, every case, every precedent represents a brick. And you have to maintain that kind of predictability for people when they're determining their outcome, whether they're running a business or making a determination in a family law case or whatever, that what the court said before is pretty solid unless there's a reason to overturn it. When you're dealing with public referendums, you're dealing with very hotly contested political issues. And you got to make sure that when you make your decision, that it's not only perceived, it's not only in reality comes from the right place for the right reasons, but it's also perceived to be from the right place for the right reasons. And the court loses confidence in the public if it appears that their decisions are made for political reasons. And I think the decisions have to be clearly reasoned so that it's absolutely crystal clear to anybody. In fact, I think the people that are opposed to the decision that you're making need to have more confidence in your decision than the people that agree with you, because that's where the rubber hits the road, because confidence is going to be deteriorated if if people think you're not doing it for the right reasons.
Thank you. And our last question, is there a judge or a justice in history or today that you most admire and why?
Well, the Chief Justice when I became a judge was Gary Alexander, and he still sticks out as to me, the way he carries himself, the way he does things. I want to emulate him. I mean, he's just somebody that when he speaks, it sounds like he's speaking truth, and it sounds like he's coming from the right place. And that's always the way I'd like to be, is when people, even if you disagree with me, you know that it came from the right place for the right reason. And that's all what I could always rely on with him, that he really truly cared about his integrity and doing what's right. And I still admire him to this day. And he hasn't been chief for a long time. He was one of the people that was the victim of the 75-year-old retirement. That's a guy that should have been the symbol of why we need to get rid of the 75-year-old mandate in the Constitution, why we need to amend the Constitution, because he was a great justice, great human being too.
Great, thank you. Candidate Larson, once again, thank you for giving the public this insight into your views and values. Viewers, please don't forget to vote by August 4th. A voter may return a ballot in person at the auditor's office or deposit it in one of the official permanently installed ballot drop boxes located throughout the state. Yes, you can drop your ballot into any official drop box. Ballots sent by mail must be postmarked by August 4th. To ensure a ballot receives a timely postmark, a voter may hand it directly to a postal clerk inside the post office and request a hand-applied postmark at the counter. When in doubt, always use a drop box. A complete list of drop box locations is included in your voter pamphlet or at votewa.gov. Thank you.